Wonderful. For our last speaker on the panel before discussion is Professor Mello from Stanford.
Thanks very much for having me. It's great to see everyone, many old friends on the committee. My background is I'm a social scientist. I do research in health policy. I'm also trained in law, and I teach torts in health law here at Stanford Law School. And I've studied the medical malpractice system empirically to try to understand kind of the epidemiology of who gets into it and what they get out of it for over 20 years. So I thought it would be useful maybe for me to address what I think is the elephant that has emerged in the room now. If administrative compensation has so many problems, is tort a better alternative for injured research subjects? Certainly the tort system is capacious enough to accommodate their claims. There has been lots of litigation brought already by human research participants. Kind of the bread and butter type of claim that we would see is an informed consent claim, maybe coupled with a product liability claim against the drug manufacturer whose product is being investigated. More exotic claims we've seen have been fraud, alleging that there was like a material concealment of some important fact about the study, negligent conduct or monitoring of the research, intentional or negligent infliction of emotional distress, breach of various patient rights that are protected by state law, violation of federal research regulations, and violation of constitutional rights. So there's lots of claims that can be brought in tort. In examining the question of whether tort is the place where these claims should be brought, I think the way I tend to think about the administrative compensation systems we have is maybe like the same way that Winston Churchill thought about democracy when he said, "No one pretends that democracy is perfect or all wise. Indeed, it has been said that democracy is the worst form of government except for all those other forms that have been tried." So my bottom line is I don't think tort is better. I think Euphemia and I agree on that. And to kind of flesh out that way of thinking, I want to make 3 points. The first point is that in analogous contexts, and I think that medical malpractice is the closest analogy that we have here, tort has not performed its core functions very well. The second point is that there's really no reason to think that research participants will have an easier time in tort than medical malpractice plaintiffs. And third, it's therefore preferable for us to focus on fixing the things that are wrong with administrative compensation instead of thinking about tort as a viable alternative. So the first point is that when we think about the closest analogs, or really, I'm going to say any other context, the tort system does not really rise to the occasion of serving its core functions very well. What would a well-functioning tort system look like? Well, it would direct compensation to all the people who qualify for it under the rules that it's set up, and only those people. So here we're talking about patients who have an injury that is redressable in tort. It's either a physical injury or a serious emotional injury. And that injury is because of negligence that has arisen in the course of care. We would expect that system to be easily accessible to anyone who has a meritorious claim. We want it to be able to rapidly weed out the people who shouldn't be there, who don't have meritorious claims. For example, by forcing information out into the open so people can understand what happened, and by effectively adjudicating early motions that are made in a case, like a motion to dismiss. We want it to be swift. And that's especially important if we care about equity, because not all plaintiffs can afford to wait, as Renee has already talked about. We want it to be predictable, such that litigants and their attorneys can make good decisions about whether to bring a claim, and also so that insurance companies can accurately price their products. The more uncertainty we have, the more expensive insurance is going to be. And finally, we would want it to be equitable in how it awards damages. And there are two components of that. Vertical equity means that the more severe injuries get more money. And horizontal equity means that people who have the same kind of injury can expect to get similar awards. So that's the vision of what tort should look like as it serves to compensate people, deter negligent conduct, and provide a sense of corrective justice, like giving people a way to air grievances and feel that others are being held accountable. Now, these things, unfortunately, just are not present for medical malpractice claims. And I will say that we know a lot about how the system works. It's probably the best studied corner of the tort liability system, and there's actually a lot of data available on it. And here's what we know. Number one, there's a lot of imprecision in who takes money out of the system. It's not all of the people who have meritorious claims, and it is many of the people who don't have meritorious claims. There are lots of reasons for that I'm happy to talk about in Q&A, but if compensation is your goal, this is not a great way of getting there. Secondly, it is outrageously inaccessible to plaintiffs. There is a reason why 85% of the injuries that show up in the medical malpractice system are serious injuries or death. And that's because it is too expensive to bring cases over minor injuries. And that's a particular problem here in our case, where fortunately, we're probably dealing with a lot of injuries that are more on the low severity side. This inaccessibility is a special equity problem as well, because the lower your income, the lower your economic damages. And so if your attorney is working on a contingent fee, they're only going to take money out. If you prevail, they're going to take a third of that fee. Lower damages awards means you're a less attractive plaintiff. So the people who tend to get into this system are the ones that have higher expected awards, and they tend to be people with higher economic damages. Our system does weed out non-meritorious claims, but it takes a long time to do that. And that's because the process of disgorging information about what happened typically takes a really long time. So we can't even get to the point of asking a court to dismiss or adjudicate a claim on summary judgment until all this discovery has gone on. A lot of money has already been invested in the case. The system is very, very far from swift. We've heard from Renee how slow the NBICP is. It is worse in tort. The average period of time between opening and closing a malpractice claim is 5 years. The median is 3 years, and it takes on average about a year for those claims to get into the system. It's really hard to predict what individual awards are going to be, and it's hard for insurance companies even to predict what overall trends in their claims costs are going to be over time. There's a lot of volatility in both of those things, especially when a state doesn't have damages caps in place. And finally, although there's a reasonable degree of vertical equity in awards, on average, more severe injuries get more money, although when you have a damages cap, that doesn't tend to happen as much. Horizontal equity stinks. People get wildly varying awards for the same kinds of injuries, and that's because juries get very little guidance, and even litigants and judges have only their own experience really to draw on in understanding what would be a reasonable settlement. So for all of these reasons, I'm not a huge proponent of the tort liability system, even though teaching about it is what pays the bills for me. The second point I want to make is that all these problems that arise in the medical malpractice system, I think, will affect the research participant context as well. And there's really no reason to think they would have an easier time on any of these fronts. Even if our system functioned perfectly, again, it's not going to compensate a lot of relatively modest injuries that research participants might have, and it's not going to compensate any injury that is not due to negligence. So if you have the philosophy that people who volunteer for research should have the expectation that if they get hurt, they will get money, that's not what tort does. Tort only directs compensation, even at its best, to people who are injured by negligence. So we wouldn't expect, for example, that to cover situations where the intervention just turned out to be really harmful and nobody could have known that, or the trial was run really well and informed consent was done properly, but serious adverse events occurred for other reasons. It's just not going to serve those people. Access problems are going to continue to be an issue, again, particularly if we don't have really severe injuries. Causation will also be difficult. Of course, this applies also to injury compensation programs that are administrative in nature, but all of the problems that we have for malpractice plaintiffs are going to show up here. Many of them are sick to begin with. It's hard to tell if their bad outcome was attributable to the care that they received. But they're especially true here where so little may be known about the safety of the investigational treatment that it's especially hard to make the call about whether it caused something. At least with measles vaccine, we have a lot of experience giving that treatment and have a sense over time of what causes what. And causation can be especially difficult to establish where we're talking about injuries to fetuses, because again, what the court is asked to do is kind of imagine the counterfactual, and birth injuries happen for all kinds of reasons, unfortunately. Showing that it was due to something that happened in this trial could be really difficult. All of the problems with damages will attach here. And those problems are especially difficult where infants are concerned. One of the sort of legendary problems with the tort system is that when we don't know very much about a person's economic damages because they're not old enough to have a job, we just take these sort of actuarial tables and make a guess. And those actuarial tables are based on the person's age, sex, and race. And they are known to systematically undercompensate minoritized populations and women because in our society, with all of its sexism and structural racism, those people earn less. So we kind of import some of the ugliness of our way of awarding damages and torts into this context here, especially when we have infants. And then finally, a big thing I want to point out is that our tort system is really inaccessible to international research participants. In addition to all these problems, there are problems associated with jurisdiction rules as well as immunities. So if we're thinking broadly about how we want to be able to compensate participants outside the US, this is not the way to go. So for all these reasons, I think that my conclusion, lastly, is that it makes much more sense to focus on fixing administrative compensation than it does substituting tort. I'm not convinced that the problems with the NBICP are inherent to its design so much as Renee described, failures of maintenance, failures of maturation in the scheme. So I think it's useful to think really hard about suggestions that Thimi and Renee have made for addressing those problems or preventing them in a new scheme. I think it's also really useful to think about the University of Washington model, because kind of a third way here is we don't need to involve the government in a compensation scheme. We can, within and kind of under the shadow of the existing tort system, create private systems of no-fault compensation that involve, private institutions sort of voluntarily stepping forward, using private insurance to finance it. Companies that offer clinical and trial insurance already have designed and offer policies that will give no-fault compensation. They do that because a lot of countries around the world require them to do that. So there's already kind of a market solution that has emerged here. And the great thing about insurance is, it's a private contract. You can design it any way you want. I learned that from the masters of insurance, Mariah Carey and Jennifer Lopez. Mariah Carey has insured her legs for $1 billion. J-Lo has insured her butt for $27 million. You can design an insurance policy to do whatever you want. So there's a lot of flexibility just in the market that could be leveraged here for institutions that want to step forward and offer this. And then a role for regulation could be to require private institutions to do that rather than to directly architect a no-fault compensation scheme within the government. So to summarize, all of these compensation systems have warts. To solve the problem of compensating injured research participants means to search for the frog with the fewest warts. And if equity is the focus, the tort system cannot be that frog. Thanks.